The first petition for consideration under this item is Petition 1458 on Register of Interest for members of Scotland's Judiciary. We last considered the petition in June when we took evidence from Lord Carloway, the Lord President. We agreed to reflect on that evidence, and we have a briefing note that summarises the issues that came up in that evidence session. We also have two submissions from the petitioner which convey his response to the evidence and also provide information about some additional developments in relation to the recusal of judges. As members are aware, this petition has been under consideration for 5 years, and I think we do have a good understanding of the arguments that have been put forward, both for and against the introduction of a register of interest for judges, and there has been some movement, I think, as well. I wonder if members have any comments on action that we should now be taking. Angus?
Thanks, Convener. As you rightly point out, this petition has been ongoing now for 5 years to this date, exactly. And I think it's worth noting that it was originally based on the consideration of a register of pecuniary interests of judges bill in New Zealand, which was subsequently dropped after we started taking evidence on Peter Cherby's petition. Now, it's fair to say we've taken extensive evidence on this petition over the past 5 years, not least from the former Lord President, Lord Gill, the current Lord President, Lord Carloway, as well as Judicial Complaints Reviewers, Moy Ali and Gillian Thompson, and we appreciate the time, clearly, that they've taken with this committee. I think it's fair to say, Convener, that this petition has already secured a result to the extent that there's now more transparency with the publication of judicial recusals, which didn't happen before. And it's worth pointing out that it still doesn't happen in England, Wales or Northern Ireland. So Mr Cherby should be proud that his petition has achieved that. However, I note that the petitioner suggested we take evidence from Baroness Hale, President of the UK Supreme Court, as well as the new Judicial Complaints Reviewer. Now, with regard to taking evidence from Baroness Hale, I feel we could be stretching the bounds of the petition, which urged the Scottish Government to create a register of judiciary interests in Scotland, and I'm not sure if we have the remit to extend to the UK Supreme Court. So Mr Cherby may well be advised to take that aspect to the UK Parliament's Petitions Committee, which may have more remit there.
I think I'm sensing we have an agreement to the approach that's been outlined by Angus there, then, that we would not be taking further evidence, but that maybe try to draw together our conclusions, and then we can perhaps write to the Scottish Government and get a response from them, but also recognising there has been progress. Can we agree that the letter is drafted and the conclusions it draws, we can agree that in private when it comes to that item, and then it will also be in the public domain once it's been considered, if that's agreed?
It's agreed, yeah.
I would agree, Convener. Can I just say, I think we do have to move this forward. It's been ongoing for 5 years, and you know, I could sense from Mr Cherby's recent submission that there was a slight degree of frustration there, which I would share.
And the letter that we were writing would also go to the Lord President. Yeah. But we understand that, but I think there should also be recognition that there has been some progress. So if that's agreed, those decisions are agreed, we can move on then